Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're going to be discussing the K-3 marriage visa. We're going to be specifically discussing it in the context of this is more, if there are other videos which discuss the pros of the K-3, this video is really going to discuss the cons. I've kind of gotten into this in other videos, but in my opinion, at least professionally, the K-3 oftentimes is not exactly the most optimal visa to seek, and I'll explain why throughout this video. Most notably, well, let me go ahead and start at the beginning. The K-3 was created under the provisions of the Life Act, signed into law by President Clinton back in the 90s. And basically, it was created at a time when processing of U.S. marriage visa cases was going really slowly. Back then, INS, which was to become USCIS under the Department of Homeland Security, they had a backlog. They had a significant backlog. It could take years to process, multiple years, like 3 or more, to process just a regular American citizen married to a foreign spouse type of visa. Meanwhile, sort of counterintuitively, I guess you could say, the K-1 fiancé visa would oftentimes take 6-8 months to process all the way through. So I even have heard of cases where folks actually got divorced in order to seek a fiancé visa. It was just faster. So basically, Congress created the K-3 as an expedient. It was basically, they said, look, we're going to take certain types of marriage visas, specifically marriage to American citizens, those foreigners married to American citizens. They can now file a supplemental K petition through the K line, and they can go ahead and get fast-tracked. Now, when it was created, that was a great idea because, again, regular I-130-based marriage petitions were taking a substantial period of time to process. And subsequently, the K-3's creation sort of sped all that up. But the K-3 is not an immigrant visa, hence the title of this video. So upon entry to the United States, the foreign spouse has 2 choices. They can either adjust status to lawful permanent residence, which requires about $1,000 just in government filing fees alone, and various other, you got to go through another immigration process. Also, or the foreign spouse can choose to undertake consular processing outside the United States. In my opinion, a real downside to this is their immigrant status is not locked in. So the K-3, although a brilliant decision, in my opinion, at the time it was created as an expedient to fast-track through marriage visas, and frankly remains such. I actually think it should stay on the books as a visa category, at least under the system as we have it, because if there comes another time where there just gets to be this massive marriage visa backlog, it can act as sort of a pressure release valve to, allow certain types of cases to sort of get fast-tracked through. But that being said, in a general context, as cases are being processed at the time of this video, I don't think it's overly optimal. One of the major reasons is it requires adjustment of status, whereas a CR1 visa or an IR1 visa does not require adjustment. That individual who enters the country is going to be admitted in lawful permanent residence, either conditional or unconditional, and they go from there. No need for further filing fees, no need for further basically dealing with any further process. The case is just, it's on file and you're in immigrant status upon entry into the United States.